right, we are back in Senate Judiciary. We have Jeff Wallen from the Vermont Crime Information Center. You're still on S12, and Mr. Wallen is going to provide some context, hopefully, about the technical aspects of sealing, expungement, and any other information that you might have. So the floor is yours.
Thank you, Senator. I appreciate that. And good morning. For the record, my name is Jeff Wallen, Director of the Vermont Crime Information Center, which is part of the Department of Public Safety. And I've had the good fortune to serve in that position for almost 15 years, just shy of 15 years in that position. And I appreciate the opportunity to come today and talk about S12 and the management of criminal history records here within Vermont. As a bit of additional context, VCIC serves as a criminal history repository and designated Criminal Justice Information Systems Agency, or CJIS. You will hear that in certain circles, the CJIS agency for Vermont as well. I also have the good privilege to serve as the CJIS Systems Officer and member of the Advisory Policy Board, which is a national organization that provides guidance on the sharing of criminal history records nationwide. I would also note that discussions around the management and access of criminal history records is happening at a national scale. Just last week, I was in Columbia, South Carolina, at a meeting of criminal history repository managers from across the nation, where this topic was being discussed at all levels. I would also note that sometimes language used around the modification of criminal history record is not standardized. The terms sealing and expungement can have very different meanings in different jurisdictions, depending on the state or locality in question. That's something that we became very clear as we were talking, that an expungement is not an expungement depending on what state you're in or locality you're in. It can be very, very different. As far as workload, just to put a bit of context around it, over the last 5 years, VCIC has processed just over 65,000 sealing and expungement orders issued by the Judiciary over the last 5 years. And during that same time, we processed just over 109,000 fingerprint-supported record checks for employment or licensing purposes. So that's part of the utility. Obviously, there's a significant utility for criminal justice agencies around this matters, but also we have a large number of non-criminal justice agencies that utilize this for employment and licensing purposes. And currently, there's no real operational capacity within our current repository to flag information or cycles, as how we term information within that system, to put additional data restrictions. Any record that is sealed does require a manual review in some capacity to make any adjustments to that record. So let me pause there. A lot of information that pops out at the beginning of a testimony. Let me pause there and hopefully answer any questions or provide any clarifications that I can.
Your last point regarding capacity to flag additional data restrictions, I think that gets to the heart of one of the main, I guess, issues you can call it, as we're dealing with S12. And so I was wondering if you could just expand a bit more on that, please.
Certainly, Senator. Absolutely. Currently, within our criminal history repository, cycles, which is an arrest, an arraignment, and then a disposition, is how that flows through our system. It's organized by cycles. Ultimately, there's a disposition for a case that's retained. Typically, you would see that as a felony conviction or a misdemeanor conviction. You might also see dismissed, et cetera. Eventually, those are rare in our criminal history repository. Right now, we do have a disposition type, what's called sealed. So that information is not publicly available. It's not available to the public, and it doesn't go out on licensing and employment checks, but it shows when a law enforcement agency queries that individual, that record has been sealed. There's no time limit. When we receive that order, we process it. It stays that way until we receive a new order from the court to change that disposition type. There's no ability to, after a certain period of time, have it be modified again without manual intervention. So does that answer your question, Senator?
It does. So just to clarify, something that's sealed right now, law enforcement can't access it?
Law enforcement can access a sealed record now, but it shows that it's been sealed. It shows that it's been sealed, so that would guide that any application or implementation of that record going forward.
Committee, any senators?
Yes. Are there any requirements as far as law enforcement having access to the records? What's the protocol for that?
Records are available on the principle that we use: the authorized purpose, authorized person. So you have to meet both of those criteria to access a criminal history record. So law enforcement, if they're conducting criminal justice activity such as investigation, they're doing a background investigation for access to a secure facility, et cetera, they would then have access to that individual criminal history if they're authorized to do so. You can't query a criminal history just because you're curious, and a member of the public can't access a restricted criminal history because they're conducting an investigation. They have to be an authorized person to do that as well.
So that would eliminate like roadside stops or whatever as far as.
Well, a roadside stop would be an authorized purpose because there's a nexus to officer safety. That officer conducting that roadside stop may request a criminal history record on the occupants within the car or the owner of the vehicle, for example, if it's deemed that's appropriate for officer safety or public safety purposes.
And last one, just how often, you may not know it, how often does that happen or has it happened?
Operationally, I don't know how often that happens. That's not data we would necessarily have. I can see how many times something is queried, but the exact reason at the moment it was run isn't something that's readily apparent in the way our data systems are organized. I'm sure that some folks who are working the road could come in and speak to how often they do or don't do that. I do know anecdotally it happens. We have questions that come up occasionally about what does this mean, or I'm seeing this record, what does this mean, or what can we do with it? And we try to provide what guidance we can, but I wouldn't want to give a percentage.
Okay, thank you.
Senator Brew?
Actually, that was my question, the frequency.
Any other questions? It sounded like you paused mid-testimony for questions, so if you have more, please feel free.
Honestly, Senator, not particularly. Really, it's very much about the system we have right now is designed to provide accurate information to authorized individuals. And it's meant to do that in a point in time system. So we get updated information from the courts daily, and we're always updating records based on guidance from the courts, or new arrest information comes in overnight, that we update that information. So the point of our data system is to provide accurate and complete information at that moment in time. It's not meant to be a long-term statistical analysis tool that can be analyzed or looked at. And that's something that occasionally we work with, like the Crime Research Group, or CRG. I imagine the committee is familiar with them. If not, I'm sure they'd be happy to come in and talk about their work as the Statistical Analysis Center for Vermont. But some of the work they do between us and the Judiciary and Crimes and others about research and pulling information together. But that's really the point of the data that we pull together and provide, is to provide up-to-date information at the moment that it's requested, whether that's law enforcement or someone applying to work in a school, et cetera. We provide that complete and updated information at the moment that it's requested. So I share that as well, because it's sometimes not always readily apparent to all of us working in that field that what this data is for has some limitations.
So just to clarify, when an officer sees, when they run that 29C III and they see that something has been sealed, is it just that, there's a label there that says sealed, but then it still describes what the charge and what the conviction was?
Yes, Senator, it would show the disposition type rather than a conviction would be sealed, but it would still show, they would see the arrest and arraignment, and then the version of the conviction that was sealed. It would show that information. It also notes flags it's for law enforcement purposes only. Purposes.
So it shows in the cycle, you mentioned 3 elements. Only one of those 3 elements is sealed?
Well, the ultimate disposition type, Senator, is sealed. So the arrest and arraignment information,
Are not sealed.
Those are not sealed, but it's all part of one record. It flows through to the end.
So can you see the arrest and arraignment information if it's sealed?
Yes, Senator. If a cycle is sealed, that's the ultimate disposition of that, is it was sealed. So I will use myself as an example, using my favorite fake crime of underwater basket weaving. It never offends anybody. I always use that one. So if I'm arrested and arraigned for underwater basket weaving and originally convicted as a misdemeanor conviction for underwater basket weaving, and later that is sealed, you would still see I was arrested for underwater basket weaving, arraigned for underwater basket weaving, and then that conviction was sealed for criminal justice purposes only.
So in other words, you can see the history except if somebody was convicted or done
Correct, because the disposition type goes from a conviction or a not guilty, which ultimately is removed. It goes to a sealed, so that restricts who can use that
So
position.
couldn't that inadvertently, let's say somebody arrested for underwater basket weaving, arraigned for that, then they're found not guilty and it's sealed.
If they're, so Senator, that's a great question, so thank you. If they're found not guilty, it wouldn't be sealed, they would just be not guilty and then it would be removed from the system at that point. Once we're notified they're found not guilty, it would be removed at that point. A sealed record is only really applicable if someone has first been found guilty.
Okay, so if I see that someone was arraigned for that crime, arrested, arraigned, and then it's sealed, I can assume they were found guilty.
I wouldn't want to categorically say that just because there are, but broadly speaking, I think that's a reasonable.
How is that sealing? Because basically, you know the crime they were arrested for, you know they were arraigned, and you've got a pretty good guess that they were convicted.
Well, I don't want to get into applications too much. However, one difference I would note is a conviction goes out so if someone is applying to, for example, work in a school, and there's a conviction, they're going to get that information. They only get the conviction, not the arrest and arraignment information. But they would see that. Or if a member of the public did a $30 query, which is available through the center, they would see that. The sealed record does not go out on those types of queries. It's not available to those entities. It's restricted to only law enforcement use, or criminal justice agencies are the only ones that have access to that. And it's noted as sealed, and then they would be expected to treat that record with whatever guidance is provided on the sealed.
I guess I'm learning now for the first time. I thought a sealed record, the whole thing was sealed, but what I'm hearing you say is that only this position is sealed.
Well, the record itself still remains available, but it's flagged as it has been sealed. In that particular instance, so.
But law enforcement can see.
Correct, it would show as sealed. That's correct, yes. And I think you've mentioned, and my apologies, I didn't mean to interrupt you, Senator, but you hit on the difference between expungement and sealing.
Yeah.
And in many states, those terms are used very differently. Here in Vermont, an expungement, once we receive that expungement order, it's as if it never happened. It completely gets deleted from all systems, which from a repository manager perspective, it's a little bit problematic that we're removing the record of government action in any capacity. But that's also a bit more of an esoteric discussion as well. However, in many states, if you do research or talk to other folks, they will talk about expungement, but they don't ever delete it. They simply flag it as been expunged or has been suppressed in some capacity. So that's an important distinction, where in Vermont right now, an expungement, it's as if it never happened. We delete all record of it. Sealing, it's flagged that it has been sealed and may only be used for specific purposes, and it's not available to the public.
Senator.
Yeah, well, so you got to a part of what I was going to ask, and that was the sort of difference from expungement. But my follow-up to that is there a point in which we can be in the middle where it is not deleted, but it is not available to anyone but the person for whom the record pertains?
Currently, within our data structure, there wouldn't be a way to do that. If it's in the system, it's going to be available for criminal justice agencies or law enforcement agencies. That term kind of gets used interchangeably depending on what you're reading. For those purposes, if it's in there, it's going to be available. So for us to restrict access to only the person, so to use myself, if I had a underwater basket weaving that was sealed and I was the only person that could get it, we wouldn't be able to get that information in our data systems.
And are there updates or upgrades to the data system that would allow that? Because this is where I always circle back to. I don't feel comfortable moving to a system where we're taking away the fact that it looks like it never happened and giving a bunch of people access to it. This is every year. This is where I get stuck in this spot.
Senator, it's a question, and I'm not an IT professional, but I feel comfortable saying it would be, if it's possible. With IT projects, in my layperson's perspective, it's not a matter of if, it's how long and how expensive. So Could something like that be developed? Perhaps, but I could not begin to guess how long or how expensive it would be to develop a system like that and the maintenance requirements that would come along with it. So I don't like categorical yes or no's, but I'm sure the ADS folks could provide some ideas on the time and expense of that.
Senator Norris. Director Wallen answered my question with explanation with example. So I'm good.
I think we'll also be getting some testimony in a little bit about a potential solution from the state's attorneys about what you just raised. We'll get some more details soonish, but there might be a solution to it. So
I appreciate that, because my concern is, so we are letting a whole host of people see it. We're just saying, oh, pretend like you haven't seen it, which like, that's not, you can't actually do that. But once you've seen it, you've seen it. It's going to bias how you interact with that person. It's going to bias how you like. That idea that because it says sealed, you're supposed to pretend like you didn't see it is sort of ridiculous to me.
Yeah, I'm just wondering from like the workload of sealing versus expungement from your point of view, it's really not too different, right? You either click a button, seal it, or you just delete the record and it's expunged. So from your point of view, it's not gonna hamper your abilities to do one or the other.
That's correct. The functional processing is essentially the same. There are some slight clicks in different boxes, but it's clicking some boxes. I would also note that with all of the work that VCAC does, there's a second level review that happens given the utility and the seriousness of these records. So anything that happens gets double checked to make sure that it was the proper person, it was the proper cycle, it was the proper whatever, the proper disposition it might be. And we do that because these are used for employment decisions, they're used for access to sensitive facilities, they're used for firearms eligibility, they're used for any number of things. So it isn't just a matter of even taking a file from the judiciary, for example, and just sucking it in the system and you're off to the races. Every one of those data points gets double checked. And the same thing with sealing or expungement comes through. It's the same essential amount of work we have to do for that, whether it's sealed or expunged. It's very, very similar operationally. And we certainly would have concern if something would create a second whole level. We'd have to go back in 10 years and revisit and modify that again, with the record again. It's not promising as well, just from an operational efficiency perspective.
And then just from a data point of view, when you expunge a record in the system, is that data point also gone? So like if we look back at historical data that in 1980, there was 12 homicides and something got expunged. I don't know if you can do that, but something gets expunged in 2025. Does that 1980 data point go from 10 to 9 because it was expunged, or is the data point still there for historical records?
So, Senator, that's a good question. I'm going to try to give you a simple answer as best I can to your question. So as far as that individual person, so if they had whatever it might be that was expunged, and you look at that person the next day, the next moment, it's really a near real-time system, it would be gone. It would no longer exist. And if you said, okay, show me all convictions for that particular criminal type from that year, it would show as gone. However, in our National Incident-Based Crime Reporting System, or NIBRS, which is a term you later use, it's a national data collection system that works off of incidents, not convictions. It's on a conviction-based system. It's a non-person, there's no PII in it. It simply gathers information on incidents and pulls them together for national comparison. In that instance, we would not go back and try to remove that, whether from 2015, that conviction from 2015 or that incident. Because it was still reported to law enforcement, there was still a thing that happened, so it's still showing that in that particular data collection. And I think you highlight a point where any type of redaction or removal of data that's provided to the center or anybody can create inconsistencies. So one data set says X, so Y, well, we don't know, we can't tell you. That would be, as the director of a repository, I don't like that answer. I don't know why these two numbers are different. I don't like that particular scenario. So,
Thank you. Senator Brooke.
So, I heard you say that it was roughly the same for you, expungement or sealing in terms of the center. But am I right that clerks in the courts under expungement have a greater range of tasks in terms of eliminating the information in their records? Because they have transcripts and other things that you don't necessarily have?
That's a good question, Senator. I would all, of course, ultimately defer to the judiciary. Your understanding matches based on prior testimony because they're not maintaining primarily a single record that's meant to be a live living document. They're maintaining multiple documents. So I would defer to them, but I believe your understanding matches what I've heard in testimony as well.
Because I forget who it was. Well, Matt Malario was saying there was no difference in the effort required to expunge or seal. But he might have been talking about the center as opposed to the work that clerks in the court or others in the judicial system have to do with the wealth of records from somebody's history. So, because I remember a couple of years ago having a lot of testimonies about what was involved physically with going through audio records and transcripts and other things and trying to eliminate pieces. Anyway. So,
I seem to recall that Matt was actually quoting something Terry had said, which I was trying to understand as well. But I remember Terry saying that it wasn't really that much different, which is what made me ask the question, like, well, why are we even doing this then? Because I've heard from everyone sitting in that chair, like, it's not really going to make that much of a difference. So I'm a little confused at this point myself.
I do remember, this was before you were on the committee, when Senator Sears was here. We had a lot of testimony about how onerous it was to go through the records and expunge, like literally destroy documents and records. I don't know who we should have into.
I remember Judge Grierson. When I was at the House talking about how frustrating it was to go through. And, I think it was microfiche, somebody called it. I don't even know what that is. But
That's because you're not 100.
yeah.
Hey, I use
So-
Okay,
Uh,
sorry.
So, in him describing how frustrating it was or how challenging it was to go through microfiche and, literally cutting out, certain names and so on. And so,
But I wonder how much that's changed now that everything's been digitalized. Like, I also don't actually know what microfiche is. But it sounds complex, but now everything's digitalized. So I just wonder how much that's still the case.
By the way, are you guys familiar with thermofax?
What?
Are these programs or what?
Thermofax, cutting edge technology in the late 80s, early 90s.
Okay.
I will regress and not talk about mimeograph machines in my elementary days as well. But I know in talking with others at a national level on this, Vermont is in some ways the gold standard that the vast majority of our documents are electronic. We certainly have archives that are physical. We still have microfilm, microfiche, physical documents that exist. A lot of states are not in that same boat. They have a centralized criminal history repository, but so much everything else within that is some of it's digital, some of it's physical, some of it's searchable, some of it isn't. It's just literally just pages and boxes or just digital documents that are delineated by nothing other than a date. So this is something that's really being discussed at the national level. But I think in Vermont, as far as the repository is concerned, our records are all essentially digital. We have a few paper documents that may come in from the court from time to time, and we enter those into our data systems and then we destroy them. So, but that is a scenario you're talking about at the national level.
I'm trying to think of who we could have in to clarify whether if it is 6 of one, half dozen of the other in terms of the effort to seal or expunge. It seems to me a lot of the impetus for the bill is illusory, because I thought what we were doing is saving, employee hours that were going into physically destroying records as well as altering digital records.
at least for me, that's maybe a third or a fourth of what the impetus was. But generally speaking, I think, and Jeff, you touched on this earlier, it's just, it doesn't quite make sense to completely delete and eradicate government records that it takes against some people. And the other piece is the workload and abilities for both prosecutors and defenders to have access to, under certain circumstances, to have access to these records, either in support of their clients.
Yeah.
Or to resolve a cold case, or there's various circumstances in which either side of the court could need access. So that's where I'm coming from. Senator Lawrence, you look like you have a question.
Well, I just wanted to, why bother with this expungement versus sealing? I mean, I think everyone is interested in making sure that those individuals who have committed a crime, have been found guilty of that, after completing everything, still have that opportunity for employment, still have that opportunity for housing and so on and forth. But there's still a nexus to maintain these records for government use. So this is, I think, the best way to get into the addressing all of the issues that we have here. You just can't eliminate, if we go into expungement period, then everything is gone.
Yeah.
There still has to be a nexus to maintaining some records for certain people. So I think it's sealing benefits, I think, society as a whole versus expunging everything. So that was my take on.
Yeah, I'm just pointing out that the single track argument was originally, in my memories, was based a lot on work hours that it was consuming, and the various departments, people, clerks, etc., were getting inundated with these requests to expunge. And then if we move to a single track, it would lessen the workload. Now we seem to be talking much less about workload and more about the needs of law enforcement going forward. So that's as may be, people will have their reasons for supporting it or not. I'm just wondering what happened to that whole workload argument, which, if you go back 4 or 3 years ago, that was the argument. That was why we were doing it. So,
Jeff, do you know if we're the only state that completely deletes records and then denies that they ever existed? Because it's my understanding, when I was researching it over the summer, it appeared that we were the only state that does that. I don't know, has that changed, or do you know anything?
Senator, I wouldn't want to speak completely categorically, but in talking with other repository managers, it is very uncommon in most states for something to be completely removed. And usually you're talking about things like a governor's pardon, or, it was the Supreme Court issued some type of order that in this case against Mr. Wallen was completely wrong, for lack of a more delicate term. But it's the majority of times the incident, the cycle in question is flagged as it's to be restricted for use. And that's really what happens. But I don't know of any other states that wholesale remove or delete records from their records management systems.
Thank you. Committee, any further questions for Mr. Wallen? Great, thank you.
Thank you for your time. Thank you.
And next up, we have Tucker from the Department of Public Safety.
Good morning, Senators. Tucker Jones, Department of Public Safety. Thanks for having me this morning. Somewhat continuing the conversation a little bit on what you're discussing here. I think it was November 2021, joint justice. This went to joint justice for a while, and it might have been Michelle Childs, I'm sure it was Brand at the time, but there was a memo at a joint justice sending it back to the judiciary committees. And it was at that point in 2021 that they recommended jettisoning the 2-track system in favor of a 1-track system. And there was some conversation in that memo that was overly complex. The system was piecemeal and had been subject to amendments over the years. So there was some general sense of simplifying it at that time for a variety of reasons. I think one of the issues in the complexity of the staff time, whenever that was being talked about, is because in the expungement provision, I think it's 7606, there is the specific provision for the courts where you can expunge a particular case, but the rest of the materials remain publicly available until everything else it gets expunged from the docket. So there was, at least at some point, and I'm not sure if practice has changed, but I remember this affected records for the state's attorneys as well when I was the deputy state's attorney, was that they were trying to essentially excise parts of cases,
Right.
which was a frustrating activity. And so that's the origin of it.
Yeah.
Current practice, I you have to kind of follow up, I think, with the courts, and the state's attorneys might have because I know they were tasked with some of that as well with their own records. But I just wanted to speak briefly a little bit just to the commissioner's kind of policy interests in S12 as introduced. Just a few kind of thoughts on it. One more minor effective date. Depending on kind of how it all comes together, you may want to consider pushing that out just a bit to allow the summer trainings on this. It's true, everyone already does sealing expungement orders and processes them, so I don't think it should be that great of a shift or burden on everyone, but you may want to allow state's attorneys do their summer training. Criminal Justice Council may want to do something for the criminal justice agencies as an update to the law. So there may be some value in like a September effective date. In terms of the substance, and this kind of comes back to the policy interests in deleting these records versus preserving them in some capacity, the commissioner shares this policy view that it is bad public policy for the government to be deleting its own records as it relates to action it's taken that affect the rights of its citizens. This is kind of the heart of criminal justice records, where you have some government action against an individual, and the utilization of those records later cuts both ways. On one side, it allows the person who's been aggrieved to actually use those records if they need to in court, but on the other side, it allows the state to defend itself against mischaracterizations of what happened, et cetera, et cetera. So that is part of the heart of making sure that we shift away from destroying the records. In my view, the real issue with expungement that we ran into was less about the conviction records, which are limited to qualifying offenses, and more about dismissed cases and deferred sentences. And the reason that was my focus on the problem with the existing scheme is because dismissed cases aren't limited to qualifying offenses. So you can have eventually an expungement order that comes down for any list of offenses, including sexual and domestic violence cases, when the case gets dismissed because a witness is not prepared to testify in court. And that's not purely a theoretical concern. This is a real issue that we've run into, where we are seeing expungement orders for offenses that are not just qualifying offenses and are not subject to the time delays of the conviction. You have to wait a certain amount of time for the convictions. Same with deferred sentences. If we look at that, there are some limitations there on deferred sentences. You can't get a deferred for anything, but the limitations aren't that expansive. And you do see deferred sentences for some relatively serious offenses. And currently, there's a process to get that expunged. And you do run into this, just discussing this on Monday with some law enforcement leaders and the members of the Professional Regulation Subcommittee at the Vermont Criminal Justice Council. And they expressed some concern about the deferred sentences and then going in a relatively short time later seeking those records, but those records had already been expunged. And some of those things I don't think weren't anticipated and fully thought through. But that is the type of thing from the field that we've, seen.
So just to be clear, so for the deferred sentences, we're talking about law enforcement, and we're talking about the instance in which a domestic assault is in a deferred sentence and it gets expunged after 2 years. And that person then, after those 2 years is up, they are applying to become a police officer, and the council wants to know, do you have any domestic assault convictions? But it's totally expunged. And so for the employment purposes, that's the issue. Is that what you're getting at?
I think from the professional regulation side, they were, essentially assessing whether to take action on a current officer. And they didn't have necessarily access to those records. And again, they know better than I do the precise circumstances, but it's kind of an example of the type of thing that I think folks have run into in the field, where all of a sudden, you have this civil, in other contexts, you have civil lawsuits. And then if it's been expunged, you have this awkward situation where you have the state essentially saying no such record exists. And there may be a situation where the records don't in fact exist. And that also is not just theoretical. This is an issue that has arisen. So that is part of the kind of general policy position that the commissioner has arrived at, that it's just a bad public practice, public policy to be believing.
Matt Valerio, when he was in, he was generally, I think the technical term is cranky about this whole bill. But it seemed to me the root of his discontent was the change in how we would treat deferred sentences. He was talking about that as established practice for 40 or 50 years. And not sure if you saw his testimony, but it seemed to me that he was making an argument that be moved out of the bill, that we were retaining current practice there. So my question would be, philosophically speaking, everybody sits down and they begin to think through expungement, sealing, the whole universe of concerns. To what extent is the deferred piece truly necessary to the bill in order to accomplish its basic aims? In other words, if we were to leave deferreds as they are, I understand that what you're saying is there's a nexus to potential questions of public safety still, even though they've met the requirements for expungement or sealing. But how serious a change in the bill would that be from the departments?
What I was saying earlier, the way I saw the current scheme of how we do this, I've never been as worried about the sealing expungement process for the convictions because it's limited to qualifying offenses, and because you have those timeframes built in there, where the issues, in my judgment, where the issues have arisen are where you have dismissed cases and deferred sentences, because you do not have the limitation on qualifying offenses or the timeframes built in there. So all of a sudden it happens a lot faster than you think it does.
Yeah.
And so that's along with what I'm saying. I almost characterize those two pieces as the loopholes in our sealing expungement scheme that we don't think about as much. And, dismissed cases as well, you think, oh, it's dismissed, so therefore it didn't happen. And so let's just get rid of it. That's a natural way to look at a dismissed case without prejudice. But, as a former practitioner, I know that I would dismiss cases for a variety of reasons. Very rarely would I dismiss a case without prejudice, because there's some indication that I made that the underlying event didn't occur. It was typically an issue in witness availability, except something like that.
But to Matt's point, is it fair to hold that against the person who was charged, given that the charges were dropped or the case was dismissed, to continue to have consequences from that case in future years, because they're based on assumptions that may or may not be true. There's no court, specifying that this is the view of the court. It's kind of like, at that point, it's everybody's opinion about that case. No?
And I think the real distinction here, when we're talking about consequences, the collateral consequences of these records existing, is what exactly are those consequences? When it comes, there's some degree of consensus. I guess you should never say that because, we'll disagree about all these things, but, giving people this second chance for housing and employment in the public sphere generally, that there's a view that that's the whole purpose of the sealing scheme, and that is achieved by the sealing of those records. I think where things break down is where there's kind of assumptions made about what criminal justice agencies are doing with sealed criminal history information after the fact. Like what and I think that's where the sticking points come from. And I think there's a lot of room for clarification there, because I don't think that there is this. I think the concerns over widespread misuse are not necessarily borne out, whether it's roadside or otherwise, for a variety of reasons. One is the mechanics of what's actually happens roadside, and that even that alone might clarify that, but also just this sense that this is that this nefarious behavior is occurring with any sense of ubiquity. I'm not sure. I don't think that's the case. And then I also, in raising this with law enforcement community this week, one of the other issues that arose is when we do pull these 29C triple I's, there's breadcrumb trails and audit tracks of all of this. So if there is misuse, that is something that is readily apparent to those who manage the system. These are all just factors to be aware of.
One thing I would perhaps want to get some more information on, testimony on, is the frequency in which deferred sentences are imposed. In my short experience, they seem to be imposed not very often, at least in Windham County. And when I do see them, they're generally for folks who don't have much, if any, of a record, and are typically quite young. So making a mental note that that's perhaps something we can get more testimony on. But I do want to talk more about the usage of information in these 29C triple I's, because I'm thinking back to the rare occasion in which I would pull that on the roadside, and you get 20 pages of information on the roadside at 3 a.m. when you're by yourself, and it's not something that you're going to be thumbing through. It's just you've hit that point where you're just about to have probable cause, or you already do have probable cause, and you're starting the paperwork essentially. And even instances after I've already arrested somebody and I'm driving back to the barracks, I'll say to dispatch, can you start the 29C triple I? And I'll grab it. And then honestly, I wouldn't even look through it if it's just a DUI, unless I'm looking for predicate offenses. So, that was my own experience. And Bob or Senator Norris, I don't know if you have any thoughts on it, but I think perhaps getting testimony from officers on the road or supervisors as to how frequently these things are pulled would be helpful, because it's not like you just click your computer and you'd be like, oh, there's a sealed record on any random person. So
and I do think it would help, because I think there is a disconnect based on just that conversation I had with a larger group law enforcement leaders just this past Monday. And I think there's a misunderstanding there of what's happening roadside. Like just as an example, I think one of them, piped up right away and said in 19 years, he remembers that happening once.
And my point would be, if it is truly that rare, why don't we just prohibit it? If it's not a tool that's in any kind of common use, and we're talking about perfecting the system, so in other words, getting rid of the deferreds, the expungement for deferreds and bringing them into the sealing regime, the single track, we're kind of perfecting law enforcement and judicial systems access to those. Why not go the other way and say on the roadside, a cop won't have access to those records?
And I think there's a good reason, like in this particular case, the example that he gave of that one time was to determine whether someone was a felon in possession of a firearm. And so there are circumstances where I think you would want that determination to be made in a pretty timely manner when they're making a decision of whether to arrest someone or not. In that particular case. Senator Post.
If someone though was a felon in possession of a firearm, that wouldn't have been an expunged offense. If they're still a felon in possession of a firearm.
It's a question of, to Senator Bruce's point, it's a question of whether they can or should be able to pull a 1029 III roadside. That's the issue, not whether or not there's a sealed offense on there. So it's just, it comes up occasionally in circumstances like that where they need to ascertain whether they have a felony conviction to begin with, based on pulling a 1029 III.
The chair mentioned a possible solution. Yeah, I think in this case, that possible solution might square the circle. In other words, could you get, like with an ERPO, could you get an ex parte order to allow you to go into the record at that? But we can take that up when that idea comes forward.
And so the only other kind of follow-up point on S12 as introduced is, it currently retains the expungement of records for municipal violations and for those who are 18 to 21 who commit an offense, during that age. One thing I note is that, so we wouldn't support those provisions that allow the destruction of those records for the same reasons that we don't support the destruction of any of the other criminal justice records.
I just want to interject real quick. And if you don't have an answer right now, that's fine, but would you support, rather than expungement, having it be sealed, but only accessible to the 18 to 21-year-olds? Yeah. That change.
And I think this is what we run into of what we mean by accessibility, because there's this kind of threshold issue when we're dealing with the criminal justice records, that they are operationally available to criminal justice agencies. So, right now there's a provision in here that limits access and use for for a period of 10 years. The problem I run into is, one, the operational issue from BCIC, also what we mean by access and use. I understand some sense of wanting to limit the use of sealed criminal history records in a public forum. That I understand where that would be coming from. There's, some balancing to be made there when, the limited circumstances in which that should occur. But right now it's just these undefined terms of access and use. And the issue that I had is, I just interpret those terms literally. And Jeff doesn't even have the current ability to literally limit their ability to access, access it. So that's a kind of threshold thing.
I guess I'm confused, and the question might actually be for Jeff. So he literally has the ability to limit access for some people, but not criminal justice. Like, I'm really confused how he can limit access for the public, or how he can, but he can't limit access for criminal justice organizations. And again, maybe it's a question for Jeff and not you. So, like, I'm confused because you do limit access for some.
Senator, it's a good question, and I think the the way I would respond to that, we have a single data source. We have a few different windows which with individuals can gain access to that. The most efficient, quick, and what have you is what law enforcement has. Let's your dispatch when they can just run someone Jeff Wallen 12.9 and they can just run that and see what's there for that, and that is unrestricted. If a member of the public wishes to access that information, because conviction information in Vermont is public, so if you know someone's name and date of birth, you can run to see do they have anything or not. That will only return anything that's flagged as a conviction, and they will only return that conviction. It won't say what they were arrested or arraigned for. It will just say Jeff Wallen was convicted of underwater basket weaving. It won't say anything else for that information. So it's going on the exact same data, but it's a completely different window to a different program that looks into that and provides information back. And then for individuals that are requesting it from access for employment or licensing purposes, so someone's applying to be a teacher, for example, that is all manual. So we have staff who go through, they look at that, they determine what can and can we release, and basically if it's not a conviction, we don't release it. But it has to be manually reviewed because we're also pulling records from other states. The fingerprint record isn't really good if someone has convictions in South Carolina, where I was just last week, and we don't know about it here in Vermont if that's a disqualifying event for that individual. So individuals have to go through there and look at that as well, Senator, say, okay, what needs to happen? And that's one of the concerns from having any type of, okay, it's relevant for 10 years or 15 years or 5 years or 2 days or whatever it is. That's one more piece of complexity that's going to significantly slow down for some workforce issues, for example. Okay, it's going to take a lot longer to process fingerprints for record checks for individuals applying to work at a school or applying to be a real estate appraiser or whatever it might be, because now there's a lot more manual review that's going to have to happen of those records. Does that help at all?
Not really. So currently we seal records. The members of the public can't see it.
Correct.
So there is a way to, what is to stop us if we decide we're going to seal records in a certain way and law enforcement can't see it unless they seek a court order to put them in the same category as members of the public?
The only way, Senator, that would function, the current way that law enforcement accesses records doesn't have the ability to filter in that capacity. It's the same way they want to see if someone has a warrant or a missing person, et cetera, et cetera. It allows direct access. So we would have to create some whole new way for law enforcement to access that data and then figure out how to flag those records they could not see through that process. Again, I don't want to say nothing is possible from an IT perspective, but
It seems like it wouldn't be that hard because basically you would route everybody through the window for the public.
Because the public already can see unsealed records and can't see sealed records.
So if you, I mean, I'm not an IT person, but it seems like you're talking about you have different windows of access. If you close the law enforcement window and therefore everybody had to go through, it would no longer be the public versus law enforcement, direct versus sealed. It would be all sealed. I'm not thinking of going quite that far, but I am wondering, I hear you saying that the system is set up for maximum access, whether it's sealed or not. And that's just the way your system operates. So it seems to me, whatever version of this passes, we have to contemplate some change in your operation. Otherwise, willy-nilly, we're just going to have open access to those records, not for the public, but for law enforcement, regardless of what the bill says. Is that so?
Well, certainly, Senator, any change to how records are managed and displayed is going to require a change in our systems. I mean, that goes, not without saying, but it goes, just to do its nature, because our systems are currently set up to provide information as authorized in the current statute scheme. I can't begin to contemplate how long that would take, what it would look like, et cetera, on that piece. But it would certainly be an undertaking that would need to happen. And I would defer to others. As a repository, we're kind of in an unusual position. We're the black box. We hold the records and we make them available to authorized individuals for authorized purposes, however that's defined.
Yeah.
The utility of the records themselves, we kind of hear about anecdotally, but we don't unless there's a misuse case, in which case we, as Tucker mentioned, we have a lot of metadata that will allow the term, who ran what when, and we can provide that for an investigation, et cetera, if we do, whenever that's requested to do that. But the actual utility of how people use records, what they do with them, et cetera, whether it be law enforcement or a school system or the Office of Professional Regulation, whoever it may be, they would need to speak to that. I would just be concerned from the repository manager perspective that we have all these different groups that are getting slightly different takes on the same data at the end of the day. Because if a record is sealed, we still have that information. It's still available. And I would be concerned that someone could justify if he's saying in one setting, yes, I have no record, but then they're denied a job work in school. But they also can say they have no record, but then law enforcement isn't aware of that incident at all.
And we're looking to simplify, and I get that. So creating different sets of rules for different individuals is problematic inherently. But anyway, thank you.
Senator.
Yes, thank you. There seems to be a lot of emphasis on who has access to the records versus the sealing of the records. And it's my personal belief that the intent is to allow these individuals to seal their records as soon as possible so they can have employment, and they can have housing and so on and so forth. If a law enforcement officer needs access to a record, and I spent 2 decades out there, for whatever reason, okay, I don't want to be that person that's responsible for either him or her getting hurt in the field. But I think that there has to be a finite scope around as to why they're asking. So I have a couple of questions. I don't know if it's going to be for Tucker or for the director here, but if we allow law enforcement to have access roadside, for whatever reason that they may want to have access, whatever else, I've never asked for access to seal record, anything roadside. If I made an arrest, I'd bring it back to it, then I'd require a 29C in my way, whatever they want to do. But is there a system that is either in place, or I realize that when you ask for 29C or whatever else, that's be this incident number that goes along with it. Just can't willy ask for these things. Is there a tracking or a database that if an officer roadside does make a request, that we could track that to make sure that they're not abusing, that there seems to be a lot of stress on abusing their powers here roadside. So is there some way that we could track that or set something up to find out the reasons for asking and so on and so forth? That's the first part of my question. I'll let Jason and I have part 2.
Certainly, Senator. Yeah, so anytime anybody submits a query into any BCIC system, there's data about that is gathered and maintained. It's not made available in a straightforward system, just like a report I have on my desk or something, but we have to have our engineers go in and pull that data. But we certainly can to say, okay, who ran this person, when, or what did this person do? How many times did Jeff Wallen run someone? What is the reason? I have to enter a reason or a case number, as you mentioned, on that. For example, most of my queries, because the sex offender registry is part of BCIC, are flagged because we're reviewing the person for sex offender registry. So it's flagged as such. So someone would go, okay, here's what Jeff did. Here's why he did it. For the same thing, for anyone calling in, whether doing it themselves or calling dispatch, saying, hey, can you run a triple I-29C on this? They'll need to enter that information. So we know who did it and also who asked for them to do it as well. So that information does exist. It is tracked. And we can make that available, again, for an authorized reason, purpose.
So that being said, there's a tracking system that is in place presently. I would think that the chief, lieutenant of the barracks, and whoever else would be more interested in as to why their officers are asking for this information, so they don't lose that access to the system here. But and my final question at this point, it's never going to be my final question, is I know that there's now Spillman and Valcor available throughout the state here. Those records that are entered, say Valcor as a for instance, property of the department, agency, or whatever it is that entered those records. So when an expungement and or sealing record comes down, I know that they used to send the court order over saying that anything I had in my files had to be expunged, removed, or whatever else because it was sealed. But what about the records in those computers that the database that we presently maintain ourselves? And what happens to that? Do they have to destroy that also, or?
I would have to defer that question, Senator. We receive, when we receive a sealing or expungement order and process it, if you will, in the current paradigm. We manage our records. Those records are maintained and managed by those agencies. So what they do, I would not want to to speculate on what they may or may not do. With those, I'm sure there's some folks who could come in and operationally and from a policy perspective, speak to how agencies manage those records and their records management system, or Spillman. But I know for us, that's what we do, but I wouldn't want to speak to how they operationalize any orders they receive.
Okay, thank you.
Who is responsible for oversight and flagging if there's misuse of records? Is the public responsible for making a complaint because they think that's happened? Is the attorney general not, like, who's responsible for that, for making sure that misuse isn't happening?
I know from our perspective, typically when a request comes in for that type of data, Senator, to your point, it's usually the agency head or their designee. They're investigating. They may have received a citizen complaint, et cetera, and so they're doing that investigation. Beyond that, I think I would again have to defer to others as far as police agency oversight, police management and oversight. But when we get those, typically it's an agency head or their designee that's investigating for whatever reason potential misuse, and we provide that data and allow them to then prosecute it, not prosecute in the capital P, but small, to move their investigation forward as appropriate.
I think that might be a perfect segue into our next witness who might be able to provide a potential policy proposal about enforcement of misuse. And I don't want to speak to the proposal, but I'll let you, Senator.
Yeah, sure.
Thank you.
Good morning. As you probably saw, I'm not on your schedule, so the proposal coming is not fully formed. But I did, before we jump into that, I just had a few notes that came up.
I'm sorry, could you please state your name for the
Yeah,
record?
sorry, we already blasted that by that. My apologies. Kim McManus for the Department of State's Attorneys and Sheriffs. Just one note on the deferred questions that came up, and I can come in another time if we want to delve further into this, but I was the prosecuting attorney for the Criminal Justice Council prior to my position. And so I do know that area and what the concerns are for those deferred sentences involving law enforcement.
And just to clarify, prosecuting attorney for the council, what did you prosecute?
Yep, so those were professional regulation cases. So I was their general counsel at the council, but when we were prosecuting an officer for a professional misconduct complaint, I was the attorney who brought that complaint against the officer. And the issue with the deferred sentences, whether it's domestic violence, there was recently a deferred in the news involving a lewd and lascivious conduct charge. When that deferred ends, if the Criminal Justice Council hasn't completed their process of noticing the officer for the complaint, having the council hearing, if that's what the officer wishes to have, if that is not all completed before the deferred ends, once that deferred period ends and those records are expunged, the council cannot use that any of those files, right? The affidavit, the public health affidavit. And so if you wish to continue that misconduct complaint based on the alleged criminal conduct, they would need to reinvestigate, refine that information. So if it was a domestic violence situation or otherwise need to re-interview that witness, could not rely on any previous interviews that were conducted during that criminal investigation. So I just wanted to note that, and again, the Criminal Justice Council can come and speak directly. Director Burkell could speak to that, but just noted that as you were all talking. So last week when it was the roadside stop issue was raised, I left here knowing that my mind was troubled because I had a deep sense that this criminal history record check happening roadside is not common, but I didn't have the information to strongly state that last week. As Attorney Jones mentioned, there were a few law enforcement officers that were gathered recently who gave a quick response to how unusual it is to do criminal history checks roadside. That almost always criminal history checks, like the big check where you would see a sealed record, is happening after the decision to arrest has occurred, and as the senator mentioned, is now being pulled together to put that case together and write up your probable cause affidavit and send it to the state's attorney. It's not that it couldn't happen, and there are rare instances where it might make sense, like the example of the firearm in a car and the possibility someone knowing that someone was a felon driving that car. There are potentially some issues where that happens, but it is incredibly rare. So this idea that officers are using sealed records to make arrest determinations, it's just not, is it possible? It's possible in sort of the realm of anything's possible, but this is not happening roadside. So when all these discussions are happening, right, there's this awareness of a sealed record, there's then access to the sealed record, and then there's use of the sealed record, right? 3 different levels of how law enforcement may be utilizing these sealed records. And I spoke to a number of law enforcement leaders this week, sheriffs and chiefs, and asked, what happens when an officer sees a sealed record because of a criminal history check, is doing their investigation, and would like to see that sealed record. And everyone I spoke to, and I did not speak to everyone in the state, but adamantly stated, and this goes to your question, Senator, earlier of the process, they said, Officer Joe cannot just open up a sealed record. Within the agency, there's an authorized person, and it is usually the head of the agency or their designee who could have access to that record. So first, the officer would need to ask for that access. And then what I was told is that the head of the agency is almost always going to be calling the state's attorney to ask, what should we do? How do we unseal this record? Because they have received an order from the court sealing a record. They are going to be very careful before unsealing it. And I say this all, and I think it would be wonderful to have chief or sheriff come in and talk directly to this point. But what it raised for me is that I believe that the best practices are already happening as far as making sure that officers are very careful about when they would unseal a record and how they would do that. And that they're already using multiple checks that I think would make this committee feel very good about the unlikelihood of misuse, or that misuse would be captured sooner than later. And
Senator Ruth had the button.
So just to be sure I'm understanding you, so the court ordered the record sealed. If somebody wants access to the record, a law enforcement officer, they go to the authorized person. You're saying under current practice, that person asks the state's attorney? Because that seems like a misstep, because it was the court that sealed the record. So why would a state's attorney have the power to unseal?
And not that they would have the power. What the chiefs and sheriffs that I spoke to said is, my first call is to the state's attorney to say, what do we do? How do we handle this? And then the instances that they recalled ever unsealing a record, they then had the state's attorney request from the court an order to unseal.
Great.
So
Just wanted to make sure that the court was involved with countermanding their own order to seal.
exactly, and that was the sentiment expressed to me, again, from a limited pool, but I think it would be good to check further, was we've been ordered to seal this. We don't mess around with court orders, so if we're gonna unseal it, we want to be very, very careful. And so all to say, something that we just from these conversations would like to explore with you is that And again, I had a limited pool, so I don't know what's happening statewide, but in this very limited pool, I have the exact same answers. That if these practices and procedures are already occurring at agencies, that we can look at those practices and procedures and create a statewide policy that would capture how best to proceed when you need access to a record, and not just access, but then the next step of use, right? How can you use it? When can you use it? And then that policy, I think, could check a lot of the concerns that have been raised. And then that's something that we would like to explore further if the committee was interested in.
Do you have a follow-up? And that's
The follow-up was just that 4 years ago or something like that, Senator Sears was proposing that there be, that a judge be involved in unsealing records. And the bill died on that point because stakeholders were not willing to go to that level. But what I hear you saying, if that's already practice, so I don't understand what the issue was 4 years ago.
And I don't know, because I'm not part of those conversations. And again, I want to preface this is a limited
Yeah.
data pool. But that's what was expressed to me is that, so I think that's what we need to explore.
Well, that
But
would take care of a lot of my concerns because the court original sealed the record, and if the court determines there's needs to unseal it, I'm comfortable with that because you literally have a judge controlling access moment to moment. I'm not comfortable with a system where court having sealed the record, other people are just able to tap it.
I agree with most of what Senator Ruth said, particularly around like if the record's sealed, other people shouldn't be able to tap in and see it. But I do want to clarify, while I always have a concern with how records might be misused and oversight generally about how records are used, my concern does not simply lie with what if it's being misused. It also lies with what I had said earlier. If in just human nature, if you see the record, you can't pretend you don't see it, even if it says you're supposed to. And so you're not misusing it. But you still did, so that's sort of where some of my concern is too, and who can see it, is not necessarily that it's misuse, but that you can't erase from your memory that you saw that.
And it's a very good point, and I can only speak to, as a former prosecutor, when I would be reviewing a case going into, and often my cases were DV and sexual assault cases, so I had flash sites often. So I'm quickly running through the criminal history check. I see notation that there's sealed records. Now, depending on what state that's from, I can tell you from experience, I think it's from Florida, you might see the statute, but you don't see information. So if you have time, you're looking up the statute. New Hampshire, it's just a case and you don't know what kind of case it is. But to your point, if I had a lewd and lascivious conduct with a child case, that's what I was bringing, that's what I was going into arraignment for. And I saw someone had multiple sealed records for sexual assault. I can't even, I'm not even, this is just for an example. Many of those would not be included, but cases that may be like, oh, it's interesting. I can't, the judge isn't considering that at arraignment, that it just, because it's sealed and it's there. Now, if I thought there was a pattern of behavior and I wanted to get into those sealed records because I thought that would somehow buttress my case down the line, then there would be all the steps that would need to be taken. But just because I note it doesn't mean I actually can use it, because there's protections there.
But lewd and lascivious wouldn't qualify.
Exactly, and I was
Yeah.
focusing the more if there were there's something.
Because it seems to me the whole scheme of qualification is a way of saying we're comfortable as a legislature with these offenses being expunged or sealed if we go to a single track, and not these others for certain reasons, because we don't think that underwater basket weaving should be something that inhibits somebody's future employment and opportunities. So I get the worst case scenario examples, but it seems to me that the qualification system eliminates almost all of them because we're dealing with lesser crimes, misdemeanors and felonies that we think are worthy after a certain period of its month. See,
Senator Bohosky.
Yeah, I mean, to the sort of flip side of that, and this is where one of my primary, and I have a fair number of concerns with the bill, but this is a big one. If you are going in and you see the sealed records, find out what the records are, and you then not even think about it, not because you're a bad person, not because, but you're misusing the information, but because you see them there, ask for higher bail or a stricter sentence. And then we dig into them and discover that, oh, they're sealed records for something that's not even a crime anymore. Like, this is where some of my concern and like anybody being, we don't have the information, we don't know, and we're human beings. We have bias and we inform our decisions with incomplete information.
And that's where the checks and balances of the system would come in. So even if I did have an unconscious bias that I saw, you know, a raft of sealed cases, and I asked for that bail to be higher than I would for someone else, the judge is going to say, on what basis? And if I said, well, they have a lot of sealed cases, the judge is going to say, that's not relevant. They're sealed. Like, I wouldn't even be able to, there's still a relevancy piece, right? Same with sentencing. Like, if I tried to bring up charges that didn't go forward, then the judge would shut me down. Like, I wouldn't be able to bring that because they would say it's not relevant.
And I think that that is great in the controlled setting of a courtroom. Now let's go roadside where tensions are high and you're nervous, I'm nervous. There's no judge to say, whoa, calm down, that's not relevant.
Right, but first we'd have to get to the step of the officer even having knowledge of that sealed record. So if you were pulled over for running a red light, civil traffic violation, your name's going to be punched into the computer. That's not a criminal history record check. That's, because they haven't asked for that yet, because they're not investigating a crime yet. So they can't do that. All of these databases have user agreements and training on how and when an officer can make these queries. And so for the traffic violation, you're checking license, registration, are there wants and warrants for you? Are there any protective orders, sex offender registry? Like, these are different databases that are not that big record check. And so I think, again, to that larger concern of like having law enforcement come in and then explain, here's when we would run a criminal history record check versus doing our usual traffic stop. I think that would be really important for the committee to hear, because it is far less common than I think you might imagine. And then, and to earlier sort of can't just, even if you have that criminal history record, there's a sealed thing, an officer can't, there's not a button to like click and pop open a sealed record roadside. Like, that's not happening.
So it's we've been throwing a lot of questions at you, and I know that you had a proposal that may address part of this. Senator Brew, do you have another question?
Well, I was just going to say, I think the distinction here is Senator Hosky's talking about a worst case scenario. You're talking about a best case scenario where checks and balances are in place. But I think it is true that if somebody has access, I don't think we can just rely on typical practice or on the idea that someone probably wouldn't be biased or probably wouldn't use it. My question is, why are we giving access if it's almost never used? Why not just prohibit access at the roadside for those officers? But to the proposal piece, is there more that you want to lay out there?
No, again, because it's not fully baked, but we did want to, no, but we wanted to put forward that we believe that a lot of these checks and balances are in place and are being done. and to have the opportunity to, we would encourage you to consider having a policy for sealed records for how and when they're accessed, and that we believe that law enforcement already is using best practices and is going far and above what I believe the committee might think as far as when they do access records. And they still want the ability for when they need it to be able to get it. But I think we can lay out what they're doing, and I think it would make everyone feel allay a number of the concerns. So I don't have this policy written. There's a lot more conversations that need to happen. I don't know if everyone would agree with it, but we had thought about it and we wanted to put it out there because we think it really could tackle some of the concerns.
And the key would be that the policy reflects solutions to the problems that we're talking about. One of which might be having a judge sign off on access. So I'm mindful always of in Vermont, sometimes it just seems to me that in our small towns, we have an epidemic of malfeasance where people are they're the treasurer in the town or something like that, and they're embezzling money. And sometimes you get reports of this in 1 year, 4 or 5 towns at a time. And I think in Vermont, we tend to believe so strongly in our own best practice culture and in our own honesty as a state that we think, oh, our officers wouldn't be misusing this. Or so to Senator Vyhovsky's point about who tracks the metadata and who's looking in, you would only find that if you went looking, but a bad actor could say, the chances are almost nil that this is going to be looked at, so I'm just going to have a peek. And then maybe that never gets found out. So to return to the basic point, if we're giving up expungement, where the record is absolutely gone, nobody has access to it, nobody, not even a judge, what are we trading it for? So it seems to me like the regime we're trading it for, the single track, has to be more exclusive than current practice. Because if it's just current practice, then we're giving up expungement for nothing. And it seems to me we're breaking faith with people who were promised expungement in the law. So anyway, I think there's merit in what you're proposing. It's just that the devil would be in the details of what that statewide policy is requiring in terms of, toughness of access.
Well, and I would like to address it again to bring in the individuals who would be doing this day to day, the chiefs and sheriffs, and of course, Department of Public Safety. There's a number of audit processes that already happen. So to your point of like, could someone and no one would know about it? In my brief conversations, they were throwing it out so rapid fire because there are so many of them, but they were like, there's a weekly audit of this, and then BCIC has an audit, the FBI audit us. Like there are all these regulatory processes in place. And I think having those explained clearly would be very helpful, because misuse of these databases, you lose your license to access them. You're not a very useful police officer, right? If you can't use these.
Although, let me guess, you could still be a sheriff.
Well, it's not like you can still be a police officer, you just can't access the database.
Could not, which would make it hard for you to do your job. And again, that we do have in place now, and from the work of this committee and others, the professional regulation subcommittee at the Vermont Criminal Justice Council is robust and responsive. And if a complaint like this came in, the agency would be investigating it, then it would come to the council. So there are protections around these possibilities if they occurred, and there's already a number of policies in place, and potentially this policy if it was looked into. But all to say, I hear what you're saying, and I think again a number of your concerns I think, Chief or Sheriff could rattle off already the protections, like just to say one thing, one chief that I spoke to was like, this idea of like the middle of the night, an officer could just be sort of rummaging around the sealed records. She explained the physical records are double locked, that she has the key, and except for, an administrator who helps with those records, if there's such limited access, like that it would take so much to go into these in a way. But she also, to the other side of your like, why do they need these records? She gave a perfect example of a child abuse case that her department investigated. The abuse happened to involve a few states, so it became a federal issue. The abuse was happening in a few different spots. The federal case took over. So this case was closed and sealed because it did not go forward to the court. Then when this case went to court, federal court, the investigators on the local level, for them to be able to testify, needed to unseal their record. They needed their investigative report. If that had just disappeared.
Well, we're not talking about continuing with expungement, so
Correct.
they'll all be available to the
Right.
judge.
Exactly. So, but I was saying, there was a comment earlier.
Yep.
You're not using these all this often. Why are we struggling with that? The need is there. It's just.
Well, I wasn't
Individual.
suggesting that we get rid of the records, but that we prohibit roadside stops from accessing them. So continuing to talk about access to the sealed records.
Senator Revelstein.
I think I'm anxious right now.
Kim, anything further?
And only if this has any interest, let us know and we can again gather some more information. And again, I think it would be wonderful to speak to a head of an agency to talk about what they already do. And I think you'd be impressed by the protections that are in place.
I think there definitely is interest in guardrails regarding access and
And a statewide policy.
the statewide policy that you would allude to. So, thank you.
Thank you so much.
So it's almost 11:30. Committee, I feel like that kind of evolved, maybe devolved into a discussion. But do we have any closing points that you want to cover for the next 5 or 10 minutes?
I'll just say again, if it is current practice to, in many of the instances we've been talking about, to get a judge to sign off on access to the record. So there's an authorized person who can see that there's a sealed record, but they can't share it without a judge. That makes sense to me. And that's the heart of what we were trying to get 3 or 4 years ago. And it ultimately was ungettable because the administration, among others, wasn't willing to consider that. But now the testimony is that it's basically current practice, but maybe inconsistent current practice. So if this new statewide policy and the bill that we're writing put that into place, it would answer a lot of my questions. That and getting rid of the OPR section would be, as long as the judge is involved, then I'm willing to rely on their discretion. It's the instances where people aren't needing to go through a judge and would then pick up the bias, perhaps that Senator Vyhovsky was talking about, that
Yeah.
concerned me.
Yeah, I have a similar position. I mean, the roadside concern, but also, when you're looking at significantly complex cases or cold cases, and you realize the breadcrumbs take you to some old sealed record so that you can find a witness, but you have to go through a judge to get there and show good cause as to why you need that information to resolve some other, cold case homicide. Allowing that mechanism to exist, I think, is important. while also creating the guardrail to prevent that concern, that fear of the implicit bias kicking in if you see a sealed record from 10 or 15 years ago. Instead of those.
Yeah, I think I could certainly be more comfortable if there's a judge involved to open a sealed record, but I do still have concerns around the interplay with deferred sentencing and of course the interplay with things that are no longer crimes. I don't think those things should show up at all. And so I still have some questions around those pieces. The other question I have that is coming up for me is just sort of the intersection with this and diversion. And then I still just have kind of general concern with complaint driven oversight. And so that's what I'm sort of hearing is that the oversight of how these records are used is largely complaint driven, which relies on the public to 1, know what misuse would be, 2, know who to report that misuse to, 3, not be too intimidated to report the misuse. And so I generally have sort of real misgivings about complaint driven oversight systems.
I think I totally hear your point about things that are no longer crimes. And maybe this hypothetical is too narrow, but I mean, I'm thinking about the situations in which somebody is, falsely charged with a crime and something that is no longer a crime. But then after some digging, that defendant finds out that, perhaps prosecutors were overcharging this thing that was no longer a crime, and now they want to file a civil suit. Or, I feel like there's an infinite number of hypotheticals in which sometimes being able to access these files is important, or at least for the defendant, so that, in the event that they realize, hey, actually I'm also missing, some property after this search warrant was executed and it wasn't justified, or, there was something shady about that prosecutor, no shade to prosecutors, but, so there's just a lot of hypotheticals that I think could be, that could happen that would prohibit, justice from being carried out unintentionally, if somebody is wronged by the government. That's my initial thoughts.
And I hear that point and generally agree with you. And what I'm hearing is that there's no way to functionally expunge that for everyone but the defendant. And my guess is that the vast majority of people would rather it not flag on their criminal history that they've got a sealed record if it's no longer a crime, than the number of people who might at some point down the line hypothetically decide they want to use that for a civil case.
I think if defendants could just get the hard copy, I think that could work.
Yes.
Yeah. So,
Well, speaking from someone who has been roadside, who has been nervous, who has been threatened, who was just a sheriff for the past 20 years of his career, I think we need to be careful. We talked about police training years ago. We talked about eliminating the so-called chokehold. And when I testified, it was, we have to be careful what we do in law enforcement. They're our last line of defense. If my only means of surviving at night and going home to my family is using a hold that's been illegalized by the county or the council, that's fine. But we can't, I agree with Kim when she said we should look at the council. I don't think she mentioned the council, but looking at a statewide policy here as far as roadside stops. But I don't think we can eliminate under exigent circumstances. And then it has to be extreme as far as allowing law enforcement, cops, to have access to these records. The same as the chokehold. I mean, it has to be that last step that they need to have access to. Should it be a policy? Yes. Do we need to control it? Yes. But I have more faith in the system, more faith in law enforcement, I guess. So those are my suggestions. And looking at the ceiling, we need to come to a compromise. And I think that quite possibly, as long as we're talking about compromises, eliminating the precautionary super ceiling.
I strongly suspect super ceiling is going to be removed from this because it sounds like it's not feasible, but yeah. Senator Matos, any thoughts? Just taking it all in?
Yeah, I'm just a little uneasy taking the roadside part away. if that were to be a thought, you know, kind of along the same lines as Bob. I have faith in the system and the officers on the roadside that are going in firsthand in dealing with these folks. If they have a reason to look into that record.
All right, well, any additional thoughts? Senator Bowski, Norris, we'll get it, Kristen.
I appreciate that there is faith in the system, and I think it's important to recognize who the system was built and made for, and that there are plenty of people who don't have faith in the system, and we really need to be looking at how we revise the system so everyone is able to have faith in the system.
Okay. All right,